Hello, good morning, everyone. I hope you can hear me and see me clearly. Thank you all so much for joining. Seeing you on a Saturday morning, very close to exam. We're super happy to have you here. So we'll just give a couple more minutes, 2 minutes for others to join. Then we'll start the presentation. Welcome. So 2 minutes, then we'll start. Okay, so let's get right to it. Good morning again, everyone. My name is Omotayo Dada. I graduated from the University of Ilorin, attended the Law School Unpacking campus, and I'm currently doing my master's at the University of Oxford, and I'll be your moderator for today. Thank you so much for joining the call, and we hope that we know that you get value for your time. So the way the presentation will go, we'll have 3 speakers. We'll have Peter Abegorin, we'll have Esther Omodayo, then we'll have Wapo. Each speaker would present for 15 minutes. After their presentation, then we'll move into the Q&A session. So please, in the course of their presentation, if anything comes up, drop your questions in the chat box. We have 7 lawyers on this call. Happy to answer your question. Please make the most of it. Ask all the burning questions that you'd have. And I would say this, the speakers will be talking to us about their personal experience. So you don't have to adopt what every single person sees. You just need to listen and pick out the important points or tips that I think you can apply. So without wasting much time, we'll have our first speaker. Thank you.
Thank you, Omotayo. Good morning again, everyone. So I'll just proceed to share my screen and we can take it up from there. Please let me know once you can see my screen.
I can see your screen now.
Okay.
It's not on
and it's in slide
mode.
Okay, I've already done that. Is it now on slideshow mode?
Yes, it is.
Okay, perfect. Good morning again. Like one of our lecturers at the time would say, aspirants to the bar. This is such a great opportunity to be speaking to you. And I mean, I understand that the tension is building. Bar finals are just about 8 days away or 9 days away. And I even saw someone's status update yesterday saying that she didn't remember that yesterday was Valentine's Day, meaning that there's a lot of pressure and you just want to, you're already counting down to bar finals. But what we're doing here today is to ensure that we're able to facilitate your success at the Nigerian Law School, and to just tell you that we've been there, God has helped us, and there are some tips that we believe will be very useful in these final days towards bar finals that we would like to just share with you. So just by way of outline, we have just about 4 things that we'll be speaking to you about. First, we'll be debunking the myths about bar finals. We'll be telling you some of the things that will assist with your mental and personal preparation. We'll also be sharing with you some recollection and memorization techniques, and then how to answer questions in bar finals. Then after that, of course, you have the floor to ask your questions and we can provide answers. So let's get right into it. Debunking myths about bar finals. So what are some of the things that you might have heard about bar finals that are not true? First is that bar finals is difficult. So I totally agree that the volume of information that you've been exposed to over the past 18 to 20 weeks have been maybe even more than you were exposed to in an entire session whilst you were at the university. But despite this, bar finals are actually quite possible to pass. I wouldn't exactly say easy, but I would say possible, because you have to, come into the understanding that some persons have gone ahead of you, even persons on this call, and we've been able to just scale that hurdle. And that makes it, confirm to you that it's also possible for you to pass bar finals, and not just pass, right? Because the goal at all times would be excellence. So not just pass, but to excel at the Nigerian Law School, which is what this session is also supposed to assist you with, right? Because we believe that with adequate preparation and understanding of the topics that you are being taught or have been taught, then it is possible to pass bar finals. Second is that the lecturers are excessively harsh in grading. So there's always that story of how it almost seems like they're out for your doom, but I don't think so, because there's really no joy for the lecturers in seeing massive failure, right? So I even sometimes see the excitement on their faces when someone from their campus finishes as best graduating student or is an award winner. There's so much joy on their faces. So they're not out to fail you. They're not out to see that you don't pass your bar finals, but there are different mechanics that they consider whilst they are marking scripts. So of course, one of the things that we were told at the time was also that sometimes what they will do is have a conversation and say, oh, this is what we taught them in our campus, this is what we taught them in our campus, and then they just find a level ground to ensure that no one is disadvantaged. The third myth is that citing more judicial authorities or even statutory authorities will increase your chances of success. Whilst it is true that having authorities to back up your answers will give you additional marks, it's the focus should really be on the principles. The principles, the exceptions, the application, right? So authorities are add-ons, but they are not the substance of what the lecturers are looking for. So whilst you try to get authorities to each principle, each topic, just ensure that you actually master the general rule, you master the exceptions, and you're able to apply in whatever scenario you are presented with. Then the third or the fourth one is that you should be very brief in your answers. Yes, I totally agree that at the Nigerian Law School, you get that notion that you should be very brief. You don't have to write too much stories. But I think that one thing I would advise is, in your process or in your endeavor of trying to be brief, just ensure that you cover the field, right? Be brief and be concise in your answers, right? So if what it would require of you is to actually have extensive answers, please do. So it's not really about being brief or not being brief. It's really about capturing every element that should be in your answers. For instance, you have a question that is focused on the exception, then you want to at least say what the general rule is, right, as a background, and then say what the exception is and apply in that instance. The other one is this thing about concentrating on commonly tested areas. I recall that whilst we were at the Nigerian Law School, it was actually one of our courses. I'll try not to say the course so that I don't scare anyone here, right? At the time, there was a particular topic that had not come out for like 5-10 years as a compulsory question, or at the time that it did, it was be of a compulsory question, right? So the easy thing was to permutate and predict that it wasn't going to come out in exams. But we got into the exam hall, and that was the first compulsory question for that course. I was almost in the category of persons who were not going to read the topic, right? Because I thought it wasn't going to come out, but thankfully that morning I read it and I got into the exam hall. To my surprise, it was a compulsory question. So you don't want to be in that space where you're cherry picking topics. You want to ensure that you actually read across all the topics, and it's always better that you have options when you're answering your questions rather than when you're stuck with specific questions. Final thing is that only university first class graduates can attain first class in the Nigerian Law School. That is totally not true. I mean, there have been very interesting stories of transformation, if I can say that. There are persons even on this call that didn't finish with first class from the university, but finished with first class from the Nigerian Law School, right? So do not be deterred, do not get into that place where you feel that because you didn't finish with a first class from Nigerian Law School, from university, you're unable to finish with first class here. So it's possible. Forget the past, focus on the now, and just make your actions and steps and plans towards the future. So at this point, I'll just go to now say, what are the things you should be considering when you are, mentally and personally preparing for bar finals? First is you have a couple of days more. What should you be doing? Develop an effective revision strategy. So I say revision because maybe there's some sort of expectation that you've at least done fast reading across all your topics. So if you've not done that, then it's probably going to be reading and revision for you. But what should you actually be looking at? What works for you? And I know that this is quite important because the pressure is increasing, and people who are not even those to stay up at night to read are also trying to just do all night reading just to cover up. If that is not something that works for you, then maybe it's advisable that you don't do it. So what might work for you is to actually maximize the day and then rest properly during the night. There are some persons that would rest properly during the day and then read all night. So just really know what works for you. There's some persons whose preference would be to read directly from their materials and they highlight. But for some of us, it is actually to write out those principles, have like a notepad where I have the general principles, the exceptions, put a case to it, and then have that small scribbled note as my way of revising. So really know what works for you. Do not get overwhelmed by the pressure and start attempting strategies that have never worked for you in the past. One other thing you want to consider is to actually have a revision schedule. So for me, I always like to have specific parameters for determining or ascertaining the progress that I have made. So what I recall doing at the time was I actually had a paper where I had a list of all the topics per courses. So I would tick a course to say for instance, in corporate law, company securities, I will mark it and put maybe 70% to indicate how far gone I think I have understood the topic. If there's another topic that I feel I've only mastered 20%, then in my process of revising, I focus more on that topic than the one where I already have 70%, just to ensure that I'm not cherry picking, right? So I think this is something you might want to adapt to. Actually have a list where you're able to ascertain the progress that you're making per topic and per course. One other thing you want to do is to consider, and which is what I just talked about, where are you weak, where are you strong, what course are you currently weak in, what course are you currently strong in, because you understand the system at the Nigerian Law School, the grading system, as to ensure that you excel across all the topics and all the courses. And you want to also ensure that you're not neglecting any course, because you know how they say that sometimes the neglected is what actually is the stumbling block for others. So what else should you do? Get acquainted. It's 7, 8, 9 days to bar finals. you should already know the structure of what the questions will look like. You will have the MCQs where you have to answer 20 questions per course, right? Making a total of 100 questions within 1 hour. What mechanics are you putting in place now to ensure that your time allocation is actually properly done, to ensure that your time management is on point? And usually for stuff like MCQ, what I would advise is that you actually start buying all those shading sheets and actually time yourself with shading, not just writing, because shading sometimes, can be more time consuming than just writing. Then for your theory questions, you probably already know that you have 2 sections. You have a compulsory question in each section, meaning that if you've cherry picked and you didn't read that topic, then you might be at a loss, right? So you want to ensure that you are able to answer whatever comes as your compulsory question. And then for your optional question, you are also able to answer whatever questions you're presented with. So practice. Practicing helps you ascertain how far prepared are you. And practicing is not for you to, like I said before, start strategizing and predicting questions that will come out. Yes, you might see that some questions have been repeated over the years, but there is no guarantee what will really come out. So ensure that now you're, just deciding, how do I want to answer my questions for my theory? How many minutes am I allocating to compulsory? How many minutes am I allocating to optional? How many minutes am I using to read the questions? How many minutes am I using to read over before I submit my script, right? Another thing you want to look at, drafting. I remember that one of our lecturers at the time would say, you don't read drafts, you draft drafts. So as much as you want to memorize your draft, the important thing is actually that you are drafting the draft. So I know that drafts can be boring. So sometimes I advise that you actually have a group. I mean, at the time, what I did was have a group where what we're doing were past questions and drafts. So I didn't have a reading group, but I had like a past questions and draft group. So at the time, we'll just look at specific questions and then draft the draft, right? So in drafting, you want to look at you instituting at the proper quote, you're putting the proper heading, because all of those bits and pieces actually would contribute to the final score that you get. So the heading of your court, if it's criminal, if it's civil litigation, what should be the title of the parties? Are you looking at plaintiff, defendant? Are you looking at appellant? Just all of those. Are you looking at, is it a case before a court of appeal or the High Court? So you want to also ensure that you are quite familiar with jurisdiction of courts, what comes before what court, right? The body of the draft, you want to ensure that you understand the different structure. If you're drafting a resolution, what is that going to be like? What's the structure going to be like? If you're drafting, if it's a motion or notice, what's it going to be like? So you want to ensure that you understand the different structures. Then for your endorsement, depending on the nature of document you're drafting, if it's a letter or it's a court process, your signature, the name of counsel, the law firm, email address, just all of these things, you want to ensure that you are familiar with what would be expected of you at bar finals, right? So another thing you want to look at, authorities, and that was what I'd, just tried to touch on a bit before. It's important that you have authorities, but like I said, the focus should actually be on the principles. So one thing I've had people ask me over time is judicial, statutory authorities, what do I do? First, I think that as a general approach is try to learn one authority per principle or per exception. But specifically, because I know the dilemma that people have with criminal litigation, my advice is always to go for cases. Cases apply across different jurisdictions. So instead of having to battle with ACJL Lagos, ACJA, and ACJL Kano, what you might want to do is actually know the cases that apply across the general principles. But in instances where there are no specific cases, maybe say for instance, death sentence, right? You might want to know the specific jurisdictional statutory authority for that. But for instances of the rights, you want to know the constitution. So it's really just to get into a place where you are not overloading yourself with information that you now mix things up. So I'll also talk about study groups. Like I said, different dynamics for different persons. For me, I didn't have a reading group, right? But I had a group where we're practicing past questions. Sometimes in the process of answering the questions, someone doesn't get it right, then we explain, oh, this is why I wrote this, and this is my understanding of it. They also provide a support system. Sometimes you're down, you speak to someone in your group. Because they are in the system, they understand what you're going through, and then they provide motivation to read. Finally, what I will be talking about is stress management. So you want to ensure that you actually rest properly before bar finals, because stress can also affect the pace of your assimilation. So what you should have learned over 2 hours, because you're stressed, you might actually have to spend about 4 hours trying to read it. You know how they say that sometimes there's someone with a blunt cutlass trying to cut down a tree, right? What he would do in 5 hours, someone with a sharp cutlass will probably do in about 2 hours, right? So when you are at that place where you feel that you are blunt, you are getting blacked out, then you want to actually take some time to rest and then continue the journey. Because of course, law school is both a marathon and a sprint. Sprint because it's about 9 months, right? Marathon because there's really no break in between. So you want to ensure that your body doesn't crash at the point where it's expected to then produce results. You also want to ensure that the stories you're listening to are not the stories of persons who failed bar finals because they neglected one course. So be careful what you listen to. I know that a lot of information might be flying around at this time, but you want to reduce anxiety. I know one of the things I did, even before getting into law school, was to just research, just look at stories of persons who had finished with first class from Nigerian Law School, just to motivate myself to see that these people were familiar with the struggles that I had been going through. And then that was motivation to continue. Finally, like I said, you and bad gist, bad information, and bad energy should be like parallel lines that at this point never meet, because you don't want anyone just dousing the energy that you're building up for bar finals and making you feel inadequate or incapable of passing bar finals. So at this point, I think I'll just hand over to Wapo, who is going to take the next part, but I hope that this has helped you just to have some sort of energy, has energized you to know that bar finals are surmountable, and we're trusting that as you go through the next couple of days, you are being equipped to just produce the information and you also assimilate what you require for the grade that you desire. Thank you very much. Wapo, over to you.
Thank you, Esther. I'm sure our participants have really had a swell time and you've learned a lot. And as Esther was speaking, I was just thinking about my journey to excellence at the Nigerian Law School. And I think it actually started when I was in university. As Esther had said, bar finals is not difficult. While I was in year 3, I told myself that law school was going to be easy for me. I finished with a 2-1 from Unilag. And, you know, there's just this, the thing about getting a first class at university is sometimes your grades may be so great, and then other times they may, you know, not be so, they may not be where you want them to be. But in law school, it's really just you giving your all at a go. You know, you're just giving 9 months to law school, and at the end of the day, you get excellent results. So law school is easy. Just focus and apply the techniques that I am going to be sharing with you, and that my colleagues would also or have shared with you and will be sharing with you. So these are some of the, I'll be sharing some of the recollection and memorization techniques that really helped me while I was at law school. And some of them you have already started applying by now. I'm sure, I mean, it's also, there's wealth of information. There's so much information, so many principles to learn. So I'm sure that by now you have already started jotting. But jotting is one of the major recollection techniques. Now, I have here that remembering the content of what you read is essential for excellence at the NLS bar finals. And that's so true, because if you read and you forget, then it's almost as if you didn't read at all. And there's this amazing thing about the human memory. You can liken it to rubber. It's very elastic. There's no there's no limit to the amount of information that it can contain. So your brain is well equipped to handle the information that law school is dishing to you, or has been dishing to you since your time started there. Now, the first technique I have here is meditation. What do I mean by meditation? Internalizing what you read. So it's not just, and I'm sure you guys have been, if you haven't, this is a technique that you may now be conscious of, but I'm sure that this is something that a lot of you have already been put into practice. So do not just read the principles, do not just read even the cases, don't just read things. Actually, try to practicalize them, try to maybe give a story, think of a story that the principle reminds you of. So in that light, or in that way, the principle makes more sense to you, and that is one way that you can really remember, because we really remember the things that we relate to. Now, another one, like I already mentioned, is jotting. So what are you jotting at this point? Let's say jotting is your superpower. What should you be jotting at this time that it's almost law school? Pretty much just bullet points. You're not jotting your entire syllabus, you're not jotting the entire things that you have been taught. You're jotting things that are summaries, maybe your understanding of the principles. And writing down your thoughts on a topic actually enhances clarity and serves as a reliable reference. So just in case you are trying to remember a particular thing, write it down. And during our last edition, one of my colleagues had mentioned that he had this list of cases that he could just always refer back to, and that helped him remember the cases at bar final. So you can also jot your cases or sections, or cases and sections down in a jotter. Another technique is self-testing. So you may be thinking right now that you don't know so much. I have a couple of law students that I'm currently mentoring, and for them, they're always like, oh, they heard someone speak, and it's almost like they didn't know, they felt they didn't know so much. But if you actually test your memory, you'll be very surprised at how much wisdom you have acquired in law school and how much you actually know. So test yourself regularly, ask yourself questions, don't rely on your books. After you have read, ask yourself questions, and you will be surprised at how much you have acquired. And through this method, you are able to identify any gap, any knowledge gaps, and refresh your memory. So if there's something you still need to learn, you are able to go back to your books and read it up. Another technique is to develop mnemonics. And if you have been reading materials like Conde Smith, you'll see a lot of mnemonics. For example, like for foreign direct participation, foreign portfolio investment, rather. I remember Conde Smith had this ABCSS mnemonic, where A stood for applying for shares, B for approval, the board of directors approval, stuff like that. So at this time, what you can do is jot down the mnemonics that you may have already formed. And if you haven't formed mnemonics, it's not too late. You can still jot down mnemonics. And for me, I sing a lot, so I really developed rhymes. Like I was just developing rhymes and learning. I developed rhymes for the times that ordinary resolution is done, the features of a lease, things like that. So you can develop songs for all these principles that, all these topics that you are struggling to remember. Another good technique is repeated recitation. So you know that repetition is the, what's that thing they say? Something about long-lasting memory. It's basically what contributes to you remembering things long-term. So repeat information again and again and again to yourself. You can also repeat it aloud. So you're just taking a walk and you're repeating the principles that you have learned. It really helps to reinforce your memory. Another one is to sleep well and eradicate fear. Esther already mentioned that this is the time where you should be managing, stress. You should not be stressed, because a stressed mind is actually a clouded mind. And I discovered that whenever I am well rested, I'm able to remember things, I'm able to think clearly. So this is a time for you to be sleeping well and not to associate with anybody that has, that could incite fear within you, because it's such an important period of your life. And just tell yourself that law school is easy, and there are so many of us. I mean, in my set, we're about 100 or 200 of us that came out with first class. So law school is easy. I mean, if you compare to the university system, law school is easier. So tell yourself that it's something that is doable and you can also achieve a first class. Now, I have another technique that really helped me because I see how law school is very broad. Our curriculum is very, very broad, you know. But one thing that's, and this is something Mrs. James used to always say, there are things that are common amongst principles. For example, you have MEMAT appearing as a document for most of corporate law procedures, most of corporate law topics. You have MEMAT as one of the documents. So if you can identify, you know, the common things that, or the common documents that are needed, or you can group, you can also group common things together. For example, directors, secretaries, auditors, right? There's appointment across board. You can identify if there's any common thing that applies to appointment. Then if there are differences, also note them down. So at this point, it helps if you just create a table with the things that are confusing you and then identify their similarities as well as their differences. And that way you are able to learn these things better and actually remember them rather. Another very great principle is communicate your knowledge to others. So knowledge shared is actually knowledge retained. So if you find someone that's struggling at this point with any principle, go and meet them. Or if they come to you, explain something to them. You would be able to see if there's a knowledge, you'll be able to identify if there's a knowledge gap somewhere. Let's say you're explaining something to them and somewhere along the line you get lost. You can always go back to your notes. And that way you will definitely remember during bar finals. So teach other people what you know and also converse with legal principles. So go, you know, just be talking as you're talking with your friends. If you know, let's say you're talking, you have some free time on your hands and you're talking with your friends, include, you know, incorporate legal principles, incorporate cases, sections into your conversations. I remember in my room then it was a joke to just be, we always used to joke with the mode of execution, you know, that way it has always just stuck. All right, so I hope that this has been able to, I believe that this has been able to impart knowledge into you. And with these few techniques of mine, I believe that you would recall the principles that you have actually learned during your time at law school. Thank you. So I'll be handing over to Peter for his part of the webinar. Thank you.
Hi, everyone. Good morning, and thank you for joining once again. And thank you to Esther and Wapo for those wonderful sessions. So I'll be speaking about answering questions in your bar finals. And Esther has talked about preparing mentally. Wapo has talked about the memorization techniques you could use when it comes to answering bar finals questions. So my job here is to actually explain how you would approach it when it comes to answering bar finals question. That is the 3 hours and the 1 hour you have for MCQ in the exam hall. And let me start with this. Answering bar finals question is not really hard, but you just need to understand the in and out, the intricacies and the techniques involved. So without wasting much time, I will start with the first tip, which is what you have to pay attention to details. Now, you must have heard this several times, maybe while in university or even you attended classes at law school. Details are very important. And let me give you an example. So when I resumed at the law school, one of the things that, of course, as you are aware of, is you would be given pre-class tasks and all. So I was like, oh, I know this question. You will see some questions like, oh, this is easy. You can breeze past these questions. But when they start answering the questions in class, I mean, after the class activities, when they start to correct your answers, you see that, oh, yes, I missed this particular detail. I missed this particular detail. So you really need to pay attention to details in the examination hall. And this starts from properly reading the instructions. I think this is not supposed to be overflowed, but I'll still say it again. Pay attention to the instructions in the examination hall. It's very important. And a very general instruction is that, oh, you answer 4 questions in all. two sections, section A and B, one compulsory question per section. It is very important. And let me tell you a story. So my roommate last year made this part very like mistake that it was only God that helped me to get a lot of. So he answered questions from section A and B on one booklet. And it was a very grave mistake that, if not for his calmness and God being on his side that time, he would have probably repeated that course, and it was proper skill of practice. So you need to pay attention to details and ensure that you are calm and patient in the exam hall. Then the next one is to take at least 10 minutes to scan through the 6 questions. So this is about being practical now. So you have 6 questions before you an essay scenario. This is what I would do. And it's very advisable because Mrs. James will only say that, oh, don't just jump into the questions, because as you jump in, you jump out. So you need to take time to read all the 6 questions, look at the compulsory questions first, look at your areas of strengths and weaknesses. I'm sure like by the time you've practiced a lot of past questions, you're able to assess your area of strengths and weaknesses, right? So the next one is to look for the ones you can answer like very well, and look for the ones that you can answer to a great extent. So you go for the best ones first. But take note. So there's this trick I adopted, right, back then in law school. So lecturers will tell you that you have 25 marks for your compulsory questions and you have 50 marks for your compulsory questions. But look at the 25 marks for compulsory questions and 50 marks for optional questions. But look at 2 optional questions. Let's say optional questions 2 and 3. And you have like 2 as A to F, while 3 as A to C. Let's say that's a scenario. But you know that 2A to F has like very easy questions or very simple questions that you could answer in like 3 minutes or per sub question. But optional question 3 just has like, let's say A to C. But you just want to, I want to save my time. I want to just answer the best to the best of my ability. And you just say, oh, let me take 3A to C. But really, you are shooting yourself in the foot because you're able to answer 2A to F very well. So what I would advise is that you should study each question, regardless of how voluminous the question is, and you have to be smart about it. So in the example I gave, so 2A to F have like very simple questions. For instance, in my proper skill of practice, I remember that they gave us some questions related to differences between legal and equitable mortgage, some particular documents in the LRL registry. I know those very simple, easy questions. They were like 2A to F, and we had a question on bills that required you to think and know. And in my set was very peculiar in terms of proper skill of practice because we had a question that was a mistake and they had to adjust and arrange. So we had like little time to spare. So in my mind, I was like, I will not waste time to answer all these bills and estate questions. I will probably take my time to think. I just went directly to the question that had a lot of like significant number of sub questions. They were very easy to answer. So that's one of the tips you can adopt. Another important tip is that you should answer the question you are asked. And law school is very particular with the operative word. What do I mean by operative word? So if they say advice, if they say list, if they say enumerate, so these are common questions that you should ask. And they would ask you to, you must have seen it in your criminal law past questions. They will say, oh, state whether this action is proper or not. You should always leave with the fact that, oh, this action is proper, this action is improper. Those are the things that you should look at for the operative words. Do not miss it. And it starts from reading your questions properly. Now, use the names of the parties very well in answering the question. I know you must have had your lecturers hammer it in your head. Use the name of the parties. And it's very important because really anybody can answer the question that law school sets. And let's say, for instance, A and B sit down together in exam and they all write the same thing. But if B is able to go ahead and say, oh, because party XYZ has done this, then this has occurred. So you know that there's a distinguishing factor between the answer of party A and party B. So that makes you very, that makes your script very attractive in terms of getting the highest marks. Then write everything in full, never abbreviate, like comma, write companies and other matters. I know you might be wondering, oh, it's a lot of things to write, but you just have to write because really, when it comes to distinguishing you, I know all of you want to get plus school, you want to be BGS, you want to get prizes. So these are the things that they will look out for. Like these are the things they will look out for. Then this part is very important, time management. I know Esther has spoken about getting like a sheet that has like mock MCQ answers, like a MCQ structure. This is one of the things that will help you to master your MCQs very well. So let me start with MCQs, right? You have 100 questions and you have 60 minutes, 20 questions per course. Now, this is one of the tricks I adopted that worked for me, or tips I adopted that worked for me. So back then, I used every Sundays, back while I was on externship and even back there at school, after externship, I would take the mock exam sheet, test myself under like 40 minutes, as I said, there 40 minutes, or even at most 35 minutes. You can never tell like the limit or the extent of your ability until you try. So I will test myself for 40, 35 minutes, 100 questions, and I will ensure that I was accurate as much as possible. So my goal back then was that anything less than 17, I must not get it. So 17, 18, and 19, because right now, when you do well in your MCQs, you start to build on it. So back then, we used to calculate. And that was one of the things I think Zion encouraged us to do back in the Lagos Nigerian Law School. So for instance, if you have 18 already in your MCQs, you know you need at least, let's say, 52 over 80 in your essay to get to an A. And at least you are one step closer to your dream of grad school. So these are the strategies you can adopt with regards to MCQ. So for your essay, you know that you have 3 hours in the exam to answer all your essay questions, 4 essay questions. And you know you have compulsory questions and optional questions. So for your compulsory questions, try as much as possible after using like 10 minutes to scan through the questions, knowing the questions you want to answer, knowing the questions you just ignore, then maybe use like 40 minutes to answer each compulsory question. So let me give you an example to make it practical. So back then, I was not very particular about, oh, this is a set number of hours I was going to use, this set number of hours I was going to use. But one thing was clear in my mind: I would not waste time in the exam. So thankfully, I know every examiner would have like work logs in the front. So as you're writing, you'll be seeing the time spent in front of the all. So back then, what I ensured was to do was that after spending like 10 minutes to look at the questions, I would, let's say, 30 to 40 minutes to answer my question 1. So you might fall into this trap, and I want you to be careful. Don't fall into the trap of writing a lot about your compulsory question number 1, such that you spend like 1 hour, 30 minutes to answer just number 1. Meanwhile, they're like, they say all questions carry equal marks, right? You don't want to fall into that trap. You want to ensure you allocate your time judiciously. So back then, what I used to do was this: if, let's say, compulsory question 1 has like question 1, so there are questions that are wicked in codes that will have like 1 to I, like 9 sub questions. I would not fall into the trap of answering all the 9 sub questions, even though I knew them very well. I would do what? I would do this. I would answer maybe 1 A to F, then I will leave some space. And that's why you have to be strategic and calm, right? You have to be calm in the exam also. I will leave some spaces between F to the next question, then I will jump to the next question. I will jump to the compulsory question in the other section. So you have to allocate your time judiciously. I know you must have learned some of these tricks in university, but it's very important in Nigerian law school, because back then, I think our civil law lecturer and civil litigation lecturer, Mr. Olaniwun would say that forget what you've read in Nigerian law school. What really matters in terms of getting your dream goal of grad school is those 3 hours that you have in the exam, and you have to ensure that you make maximum use of that 3 hours, those 3 hours. So do not panic if you make mistake. You always have time. Now, let me tell you the story of my friend again. He had written I think one of the compulsory questions or an optional question in the other booklet, and time was fast approaching. Thank God he did not panic. What he just did was that he tried to detach like manually, although it was rough, but thankfully for him, he did well and he had the first class. So whenever you make a mistake, don't think that that's the end of your law school journey, or that's the end of your dreams, grad school dream. You can always have time to correct it. Then let's talk about structure. Talk about the things you should do in terms of time and managing yourself in the exam. But let's talk about structure. And when I mean structure, I'm talking about the way you answer your questions on the paper, or how you write your questions on the paper, like answering them in the exam. So, for instance, they give you these questions. They advise Mr. Smith on the propriety of the action. As I said, you have to lead with the answer to that operative order. This is advice. So you say, oh, Mr. Smith's action in doing XYZ is proper. Mr. Smith's action is improper. Then you start with your reason, then with your application and with your conclusion. But take note that I had to answer questions for my own experience. I think each course has its peculiar way of answering the question. And you can only master or own this skill when you listen to your lecturers properly and you solve enough past questions. So in terms of structuring your answer, you know that you have to answer what you are being asked. You have to provide reason. And if time permits, and if you want to really do, you need to supply authorities and you have to conclude. So structure your answer properly. And this is the way to approach it. Try and think of yourself as an examiner, that is the person that is marking your scripts. And if they ask you a question now, so if I'm the examiner, would I be encouraged to give myself the highest marks possible when it comes to answering those questions? So that's the question you need to ask yourself. Think like an examiner. That's what some of the lecturers are doing. Think like an examiner. Will lecturers be joyous to say, oh, this is a fantastic answer. Let me give this person the highest marks possible. So the next one is style. Style is very important too. And I think one of my mentors used to say that, oh, you have to punctuate, you have to write semicolons, you have to write full stop, you have to write comma. I thought it was being very fastidious or pedantic or trying to be so meticulous necessarily. But what I realized was this, that when it comes to distinguishing between the good, better, and the best script, these are some of the things that we take into consideration. And some lecturers told us back then in law school. So you have to ensure that you put full stop where you're meant to put full stop. You have to ensure that you put semicolons where you're meant to put semicolons. If you're asked to list, you have to start with the preamble. And I know you know this by now. Say, for instance, in corporate law, they ask you to list the regulatory authorities that apply to a particular scenario. What you need to do is to say CAC, Corporate Affairs Commission, Standard Organization of Nigeria. You list them accordingly. Then let's talk about each course: criminal litigation, civil litigation, corporate law practice, property law practice, and professional ethics and skills. So for criminal litigation, it is like very sure, like 100% sure or 99% sure, because nothing is certain. You cannot escape charges. You have to draft charges. And the only way to draft charges, as Esther has said, you cannot cram that. You have to draft. Practice your charges. Practice. Back then, we used to practice. We show each other. We compare notes. We even take some of our lecturers. We don't know. Your lecturers are very approachable. And you need to practice and show them so that they can correct you. You have to master the Evidence Act, because question 4 most times is, trial section 215 or 216 or 217 of the Evidence Act. When it comes to examination, achievement, like, so you have to master those specific areas. Then you have to master your statutory authorities. But as Esther said, when it comes to criminal litigation, statutory authorities can still be forgiven if you don't remember. But most importantly, remember your case law. Then for civil litigation, it does start with the concept of jurisdiction. It's very important because I know you must know by now that, say they give you a question in civil litigation, and meanwhile you're meant to commence your action at the High Court of Lagos State, or you said, it's Federal High Court. Like 90% of all the other answers would radically change from the expected answer. So you need to master the concept of jurisdiction such that subject matter, you need to be conscious of which court you have jurisdiction when it comes to different subject matters, the parties, and even the location. Very important, because for land matters now, it's the courts, the division where the land is situated. That's the matter when it comes to land will be situated at. Then, as I've said, you have to give definitive response to the answers. Then the next one is corporate law practice. I cannot overemphasize, grammar should be your best friend. Like, it's not advisable to cram grammar, but you should not miss any critical components when articulating your answers. So to just summarize, let me give you a practical scenario. Section 245 of CAMA says that failure to give notice would invalidate the meeting, but there's more. So let's say a good student will say, let's say a scenario is that what is the effect if the company does not give notice to member A? A good student just, it will invalidate the meeting, but CAMA still says something further. CAMA says that failure to give notice will invalidate the meeting unless failure to give notice is as a result of accidental omission. Section 245 does not stop at that. It still says that, however, accidental omission does not mean where you misrepresent the provisions of the articles or you misrepresent the provisions of CAMA itself. So for a very close student, why not necessarily cramming section 245 of CAMA will still state all these important components to attract the highest marks possible. So you see the point I'm trying to make now. You need to be very holistic in answering some of these questions, and you can only do that by practicing. Don't cram grammar, but understand the components, like let them become part of it, such that when you are seeing the question in the exam, or this is the right thing to do, these are the principles that the authorities need to supply, and you must pay attention to details, please. And when you are drafting your drafting codes, do not ignore the minor details. Like, it goes so bad that most times in Lagos campus, when you finish classes, you draft, and you go to show them on upstage. And back then I used to get 2.5/5, 3. I was like, I've missed anything, but most times I will discover that it's just the details. For instance, dates. Sometimes dates carries 1 mark in corporate law practice draft. Sometimes it might be very wicked to make it carry like 1.5 or 2 marks. Dates, RC number, like special resolution. You write resolution instead of special resolution. So these things are very important to take note of. Then for corporate law practice, for property law practice, it can be very interesting because this is where you need to pay attention to details the most, because the jurisdiction can change your answer. For instance, if you write a PCL jurisdiction instead of a CA jurisdiction, it might radically change your answer. So please pay attention to details in the exam. Understand the particular thing you need to address. Then ensure you learn the locus class course for notorious principles. This is very important because let's say for lease now, Otola and Paper Sack, these are important cases. And back then in Lagos campus, they used to do this thing. We used to have this drill such that for each particular topic or for each like important principle. You need to know the locus class because they will tell you that, oh, let's say for instance, an examiner sees your script and sees that you've mentioned this particular case. They are all humans, and they will be more encouraged to say read your script and be more patient and to give you the best marks possible. Then, when faced with seemingly ambiguous questions, answer in line with possible scenarios. So this is my experience. Sometimes you face with a very challenging question in property law practice, and you know that, oh, this answer A might be right, answer B might be right. So what should I do? Back then, what they used to tell us that, oh, just write both of the answers. Lecturers are magnanimous in quotes to the extent that they would, oh, see, answer A, yes, you need to answer A, let's give you the marks, then just ignore answer B. So please, if you are unsure, write the, and you have to be smart with your time, write the possible two answers. Then for professional ethics and skills, as I said, they can be very methodical, such that you have to move from step A to step B to step C to step D. Ensure that you learn your RPC. Don't miss your answer step by step, because everything builds up to an ultimate answer. Learn your RPC, don't cram. Make sure you understand the different components of a particular of the RPC. So for instance, Rule 22 says that you cannot visit a client's house or something like that, but there are exceptions, and under those exceptions, there are instances. So you have to pay attention to that. Now, go to the extra mile, try to learn the sub-rules, because some of these questions in your professional ethics and skills would require you learning the particular component of that sub-rule. For instance, let's say there's a sub, I know there's a sub that speaks to the fact that if a lawyer has represented a client in a particular case, then ex-members of the firm also should not take up that particular case again in situations of conflict of interest. So you need to learn all those sub-rules and ensure that they are your fingertips in the exam hall. Then moving on, let's look at some of the common topic trends. And let me add a disclaimer here that all these topics are reflective of trends over the years. So Nigerian Law School may set topics from any area as it deems fit. And I know you remember what Esther said at the beginning of our session, that law school just decided to surprise them during their set. So you need to be very smart. Why not relying on some of these common topic trends? You also need to be very smart. So the first one is criminal litigation, pretrial investigation, bail, charges, jurisdiction, trial 1, 2, and 3. So these are some of the common topics we've seen over the years. Then the second one is property law practice. Property law I think this is like 99.9% certain that they will ask you what transaction it is and what documents, even like the laws that are involved. So you need to pay attention to that particular topic. Then for leases, covenants in leases, they are very important to learn. Sale of land, like all those stages, very important. Effect of the contract, effect of the deed of assignments, then even perfection too. You can't escape that in property law practice. Then for wills too, which is a very common topic that comes back. And as you must have seen in your practice, past questions. Then the next one is corporate law practice. Post-incorporation matters. So how to change from limited to a private limited company to public limited company, how to change your name. Those are like procedures that are very important that you really need, because let me give you a very interesting story. So I had a friend, thank God he passed. He was so focused on mergers, he was so focused on acquisitions, he was so focused on liquidations. Like, those are the things he read before the exam, your corporate law practice. And if you've seen our question, you see that most of our question was just that post-incorporation matters topic and other simple topics that you don't think that, oh, law school will not just want to test us on this. And this is a very important point. Don't neglect the seemingly simple topics for the harder ones. So you just focused on measures, and they brought all those questions on post-incorporation matters. Was devastated when he finished the exam, but thankfully he passed. So corporate governance, regulatory bodies, like what are the regulatory bodies that will apply to this scenario? Then the fourth one is professional ethics and skills. So history of the legal practice, very important. Like notorious rules in the RP, such as Rule 17, Rule 20, Rule 22, and I think Rule 23, right? When it comes to client accounts and client money. Then law office management and interview. They might seem like very simple topics or very easy topics that you can just overlook. But let me share another story to conclude and wrap up. So that was 2023. My last journey was 2023. I was just focused on the big topics in professional ethics, all those rules and all. But my friend just said, oh, Peter, I have this notch that we should just read this law office management, types of law office equipment, law office machines. I'm like, these things are so basic now. But interestingly, they came out in the compulsory question. And I just thank God today that I actually needed, like, I heeded to advice and just read those particular concepts or principles. If not, it might not be good. So improper attraction of business, then legislative drafting. It's very important because you need to pay attention to details, because what they really mark Most of the answers are just one-liner answers, but what they really matter is the punctuation. The punctuation, maybe I meant to write capital letter here or not. So you need to pay attention to details. Then the last one is civil litigation, as I've mentioned, jurisdiction, high court proceedings, pleadings, judgment, trials, and appeal. Then the most important one, fantastic four. I don't think you can escape any of these in a civil litigation exam. And interestingly, law school decided to ask all the four of them, or two or three. So you need to pay attention to these topics. And with all of this, I hope I've been able to explain how to properly approach bar finance question in the exam halls. Thank you. Over to the moderator now.
Gosh, thank you so much to our amazing speakers. I have so many notes here. I wish OA organized this before I went to the law school. Maybe I would have had a better results. Thank you guys so much. Very, very important tips. Before I go over everything that has been said, I just want to remind our dear attendees, please drop your questions in the Q&A section. We have 7 people, 8 including myself, on standby to answer your questions. So just to briefly summarize all the great things that have been said, I'll start with the last slide. Please, OA is not giving you AOC for your exams, so we are emphasizing areas that might come up, but it may or may not come out. So please read as much as you can. Esther talked about the mindset, talked about time management, talked about how not getting a first class from undergrad doesn't determine your grade from the law school. I mean, I had a 2-1 from uni, WAPO had a 2-1. So if you had a first class from uni, fantastic, excellent student, you're on track. We hope you replicate the same thing. If you had the first class from uni, you're on track. If you had a 2-1, a 2-2, whatever your grade is, law school is an equalizer. Everyone has a shot, so make the most of the new slate you have. Let's call it a new slate. Then the right mindset, it has been emphasized. Please have the right mindset. Surround yourself with positive things. Listen to a few days to the exam is not the time to go and be reading sad stories of people that had all A's, people that made mistakes. So listen to people that did well, watch videos. I was always on YouTube. Any little thing like this, BGS, past years, I would just look at them to remind myself that, oh, people have done it. I can do it. And another thing about having a positive mindset, few days to my exam, I answered one MCQ and I got 4/20. My God. I was devastated. Like, what is this? 4 days to the exam? Well, I kept telling myself that, oh, you know what? Do you want to lose the mark now or do you want to lose it in your exam? So I just told myself it's best I make the adjustments now. But we found out that there was an issue with the question, but it was still nerve-wracking. What do you mean for 20 this close to the exam? So even if you are making mistakes now, don't freak out. Just see it as an opportunity to learn and to make whatever corrections you need to make so you don't have to lose those marks in the exam. So many notes here for you guys. I'm almost jealous of you people. Then the other thing is to be calm, because you might get into the exam hall, you might see questions that you don't know, and you should not immediately panic. I know there were some questions I saw that I did not know. Then I went on to answer some other questions. And you'll be so surprised at how much your brain will cooperate when you're in the exam. Like, your mind will just start bringing back some of the things you thought you have forgotten. So be calm. They're very important. Please, when you're about to start your exam, pray that God, please help me remember. I know in law school I prayed a lot. I used to tell people, I used to hold God's trouser, like, please. I read, I did my part, but I was just very conscious of how much the help of God could do for my results and my exam. And the last thing I'll say is that when you get into the exam hall, as much as compulsory questions they carry a chunk of your mark, I would advise that you start with the question you know best. So even if it's not a compulsory question, start with a question you know best, because that's the first question your examiner will mark and you want them to see you as an excellent student. So if you start with a question you don't know so well, they might already see you as, is this a strong candidate? Is this not? But if you start with a question you know, you are giving them answers, and when you get to later parts of your script and you are making some slight mistakes, they might be inclined to use their discretion in your favor. As much as there's a marking scheme, they have their discretion. So you want to present yourself as an excellent candidate and Another point, funny point that Peter made, managing your time. You don't want to spend too much time on one question. I remember my property law practice. Property law was my favorite course. And the first exam, I was like, I want to impress my markers. Then I was writing. My writing was so neat. 45 minutes, I was still writing question one. I had to tell myself, even if you write the best answers, you can't get more than 25 marks for the first question. So manage your time, write well. So again, thank you so much, Esther, Wapo, Peter. Thank you for the tips. And we trust that people on this call would come back with good news for you guys on LinkedIn. So we'll get right into the Q&A sessions. We have a couple of questions already. So like I said, some people will be assisting us to answer this question. So the first question, is there negative marking? And will examiners penalize for citing wrong authorities? So Victor Nibe, please, if you'd be kind enough to answer this first question.
Yeah, good morning, everyone. Thank you very much, Wapo, Peter, and Esther, and Tayo as well. So the question on negative marking is really one of those myths that exist about the law school, that people believe that if you answer a question, the MCQ, incorrectly, you can be penalized past that question. So what negative marking is that, let's say you fail number one. Instead of you just losing the mark for failing that one, you also get other marks deducted. And that's what negative marking is. And I believe, as far as we know, this does not happen in the law school. Especially in MCQ, when you fail a question, you only lose mark for that question. And the problem with having people believe that negative marking exists, the dangerous problem with it is that it makes people skip questions that they don't know the answers to. So you see a question, you for sure, I don't know the answer to this question. And because you fear that answering it incorrectly will mean you lose more marks, you skip it. And that is wrong. So for your MCQs, even when you're not sure of a question, or when you're sure you don't know the answer to a question, still answer something. Okay, don't leave it blank, because there's still a 25% chance, statistically speaking, of you getting the answer to that question. And if you leave it blank, you're sure to fail that question in particular. Leaving it blank won't also mean you get marked negatively, but you lose the mark, that 1 mark for that question. So there's no negative marking in MCQ or in theory. You lose marks for questions that you did not get. Simple and short. Now, will examiners penalize you for citing wrong authorities, incorrect authorities? The trick with authorities is this. Like it was mentioned earlier in the call, the principles are much more important. If you get the principle right, your marks are sure, almost. So for authorities, perhaps quarter mark here and there, it's important to learn them, it's important to know them, but they are not a must, so to speak. I feel like you can actually still get a first-class grade, even if your authorities are not on lock. That being said, know your authorities. Now, for wrong authorities, it's advisable to not answer at all with authorities, as opposed to answering with completely incorrect authorities. Authorities that if a lecturer says, it will signal to them that you don't know what you're saying. You don't want to do that. So it's best that your principle already looks good and is nice, and that there's no backing authorities, than writing good principles and then you go and cite something that is completely off point, But I guess the trick for this is you can cite a more generic authority. So sometimes there are cases that apply almost completely throughout a topic, right? And you don't quite know other smaller cases in that topic. So there are many principles in every topic, right? And there are cases for each of those principles. And yet there are cases that run through. So if you see a question that you don't know the particular authority that works for that principle, maybe you can just put the generic case that still applies to that topic. I wouldn't advise you to cite an authority that might just be completely off point, even though you probably not get marked. You won't get marked wrong for it, but it's not it doesn't send a good signal to your examiner. And a lot of things in writing exams is really to make your examiner feel like you know what you're doing. So the simple answer is cite generic authorities if you have to. Don't cite wrong authorities. It's better to even have no authorities and have good principles than to cite the wrong ones. Yeah, I think that would be my answer to that. Thank you very much.
Okay, thank you so much, Victor. And Victor had the first class he attended Port Harcourt campus, because we've had Lagos people dominating this call a little too much. So
Yeah,
thank you for your response. Then the next question, that Majid would assist us in answering. Please, how do you memorize suit number when drafting each process? For example, motion on notice, motion ex parte, injunction, in civil litigation. Majid, please, can you assist with answering this?
Thank you, Omotayo, for that, and thank you to the speakers. And so the question is pretty straightforward. How do you memorize suit number when drafting each process? I'll simply say you don't have to memorize suit numbers, right? What the examiner wants to see is that you know the appropriate place in your draft where the suit number should be. So for instance, you know, after the heading of the court before the parties clause, that is where you have your suit number. So basically what your examiner wants to see is that you have it written there, that suit number. So you don't have to memorize specific suit numbers for each application. You can just have a generic you can just know a generic suit number, and you just know that what changes is the name of the court or the jurisdiction. But you can just have, so typically for High Court, you can say HC/ABJ/11/2025. Just have that at the back of your mind, and you know that the only thing that is going to change is ABJ when it's for Abuja, LAG when it's for Lagos. And you can even decide not to have anything at all there, right? But the most important thing there is for you to have, for your examiner to know that you know the appropriate place where the suit number should be. I would think that it's just out of abundant caution that you would be writing those suit numbers there. So you don't have to stress yourself about memorizing what is particular suit number for injunction, for motion on notice, for this and that. Just have a generic suit number. What will be changing is the court and the local jurisdiction. So you have HCABJ 11/2025. When it's for Lagos, HC/LAG/11/2025. When it's at the Court of Appeal, you change it to COA/. So it's just for them to have an idea that you know that the suit number should come after your heading of court before the parties clause. So I think that would be my answer to that question.
Okay, thank you, Majid. Then we have another question that Ekundayo would be assisting us to answer. Are there different ways to answer questions for different courses? For instance, should we write longer answers for property law practice and professional ethics and skills? So Ekundayo, please, can you answer the question?
Thank you, Motayo. So I wouldn't say it's based on courses per se. I would say it's based on the nature of the question. So as you know, some courses can ask you, list the procedures. So I think in corporate law or property law practice, you can be asked to list like a procedure for doing something. Or maybe you can be asked to list, or what's the timeline for maybe commencing an action. So it depends on the question you're asked. So if you're asked to explain or maybe advise your clients what's proprietary otherwise of doing something, you know that, okay, you're going to start from stating the general rule. And even if your answer is in the exception, you still need to state the general rule, right? You need to write inside, because I know that you might want to be brief, right? But you also need to address all points like Esther advice. So it depends on nature of the question. So even if you ask, what's the timeline for doing this? You don't need to just state, 14 days. You need to lay proper foundation. Let's say maybe 14 days from so, or what's the time for filing a reply? Maybe within 7 days from receipt of statement of defense or something. So if you're asked to answer a question, it's not because you're answering, this is how to answer corporate law, this is how to answer property law. So it depends on the nature of the question. So the nature of the question that will determine how you're going to proceed in answering the question. I don't know if that.
Yes, it does. It does. Thank you so much. Next question. Where do you get the recording from this seminar? Last time I checked, I was informed that those that are registered will get a link and they'll have access to the recording. So I think you'll get the recording after. There's a question I was hoping would not come up. Peter, this question is for you. Please, can you recap on the 4 surefire areas that are likely to be asked in civil litigation? Before you answer, I need to reemphasize the points. We are not giving you AOCs. This is just us predicting what might come out. But you remember what Esther said? We had this prediction in my set and we were surprised. So please, this is just saying what has been coming out, not what will come out. But Peter, please, to recap.
Yeah, thanks for the clarification. So to recap, the 4 notorious areas, we call them notorious areas, topics I do: fundamental rights enforcement, petition, election petition, matrimonial causes, and recovery of premises. So you typically take these topics at the very end of your civil litigation journey in Nigerian Law School. So, but really, I think over the years, law school typically has like at least 1, 2, or 3, or even 4. So you just need to pay attention to those topics. Hope that's answered the question.
Okay. Thank you, Peter, for your answer. Someone asked if the slides will be made available. I'm not so sure about the slides, but I think someone can help me check. Then the answer will be typed in the chat box, so you know whether or not you get the slide. Or Esther, do you know if the slides will be sent?
I'll just double check and confirm in the comment section.
Okay, thank you so much. Another question for Peter from Paul. Paul says, good afternoon. Peter, you mentioned that there's a different approach to answering questions from each course in the law school. Can you kindly attempt a random question to explain this better? I think Ekundaya touched on this, but Peter, do you want to come back again and just attempt? Brief example.
Yeah, thank you. So, to be clear, let me start with saying that, as Olabisi said, I think it's more dependent on the nature of the questions than the concepts. So, but regardless, you would note that over the years, there are certain ways which you answer some questions. So, let me give you a practical example. For civil litigation, say they ask you, in what court would you commence the action? You need to start to say that section 175 of go straight to the point. The appropriate court which to commence the action is the High Court of Lagos State. If it's a land matter and they give you the particular land location, you say in Ikeja Judicial Division. Simple as that. Then you supply, you give your reason. No, this is because the matter is in Lagos, the defendant resides in Lagos, so the contract was meant to perform the Lagos, and it's a land matter, land is located in Ikeja Division. Then you supply your authorities, probably, or the whatever, then you conclude. So that's for civil litigation. Say for corporate law practice now, you have a scenario that deals with, let's say, the manufacturing company wants to deal with manufacturing drugs. They say, what are the regulatory bodies that would apply to this scenario? As always, start with your preamble in corporate law practice. The regulatory bodies that will apply to this scenario are 1, Corporate Affairs Commission, 2, Standards Organization of Nigeria, etc. Then you put your stop. Property law practice, advise party A, B, and C whether there's perfection with respect to this transaction. Perfection is threefold. There has to be consent, stamping, and registration. So in answering that question, you have to divide your answer into 3 sections. You have to know whether there's consent, you have to know whether there's stamping, and know whether there's registration. So in that regard, so once you have to state your principles of law in those 3 instances, then you apply your principles of law, then you conclude. So property law practice, in my own experience, is very similar to how you answer your university questions in terms of IRAM. So what's the issue? Most times the issue would have been identified for you when you state your rule of law, you apply, then you conclude. That was how I answered my property law practice questions. Therefore, criminal litigation is similar in my own experience to civil litigation. For professional ethics and skills, as I said, it's methodical. Start from your generic principle to then you tunnel down to your specific principle that you apply, then you conclude. I hope that answers your question.
Yes, it does. Thank you, Peter. So we have another question from Declan, and Adeswa would be answering this question. So I'll just read it out now. From the last speaker that spoke about how to answer bar final questions, he mentioned that you're citing a particular section of comma relevant to a question. A good student will not jump at the particular section, but would go on to cite further exceptions and subsections of that legislation. So my question is, how do you do this without overwriting in a particular question? So that's the first limb. How do you say the general rule, cite the exception without risking overwriting? And the second question is, how do you understand and not cram comma? So Adeswa, please, can you respond?
Okay, so in answering that type of question, usually a question is focused on a particular exception. So if a question is focused on a particular exception, you can just say the general rule and then cite only the exception related to that question, so you don't overwrite. Like what is most important is stating the general rule and then going ahead to just highlight the exception related to that question, so you don't overwrite or write too many exceptions. You don't have to like go because, and again, there's not even time to do all of that. So just make sure you state the general principle, state the exception, and then relate it to the question. Then for your question on understanding and not cramming comma, yeah, I know that comma is very bulky and it's a bit technical, like more technical than the other courses, but you don't have to cram it. You actually don't have to cram it. There are some parts that you might have to cram, but not every part. That you just try and relate it to what you understand. Like what I and my roommate used to do then was we just like talk about it. When you talk about it a lot of times and just like try to create scenarios around the particular sections of comma, then you just see that it sticks. And also I kind of emphasize the importance of repetitive reading. Just keep reading and reading, and you just see that it just flows naturally. So you don't have to necessarily cram, because if you cram, you might forget and you may not even understand the principles exactly. So just try and create scenarios around. You tell your friends, you can just remember a section. I remember that time I'll just remember a section and then I'll just say, oh, what's this section? You just say it out and then your friend will just explain it to you. And then also past questions help for corporate law practice. By the time you practice past questions, this is the time to like practice your past questions like a lot with, and not only alone. Don't practice your past questions alone. It's better to practice past questions with your mates, so you can see how different people approach answers to questions. So I hope I've answered your questions.
Thank you for your answer. I hope the person that asked is satisfied. So we have another question that Victor would answer. Would you still get full mark for statutory authorities if we only know the general section and not the subsection? So I'll just say this before Victor answers. In my exam, there are some sections that I did not know the subsections, and I just put the statutory authority. And the mindset I had was that some of this information, I will not use it after the law school. So I'm giving these people all I have in my head. There's nothing that I've used rule 20 something, rule something to do. So have that mindset. If you know a rule or you know a section, but you're not sure what the subsection is, I think you can still include it. It's better for you to do that than to come out of the exam wishing, oh, I wish I wrote this, maybe I would have gotten this mark. But I'll let someone else answer. So Victor, please. Still the same question.
Yeah, I'd like to point out first that Omotayo did that and became best graduating student. So
Yes.
it's a clear given that if you know a general section, because you don't know the subsection, it does not mean you should not apply that section. It's an authority regardless, right? So if you're blessed and lucky that you know the general section, put it there. Of course, when you're studying, it's advisable to memorize as many sections and subsections as possible, especially the very important ones, right? But when you're faced with a question in the exam hall, you're already here, you realize, oh, I don't know what subsection applies here, but I know this general section covers it. Very advisable, put the section there. It signals to the examiner that you know what you're doing. Don't skip out. Yeah, that's my belief as well. And that's what I did as well when I wrote my exams, because it's almost impossible to know every single subsection. There are so many.
Thank you, Victor. Thank you. Then we have another question that Majid would answer. I'm not a law student yet. As an aspiring law student, some people would say that you should start preparing ahead. Some would advise that you rest and that it doesn't necessarily change anything. What advice would you give an aspirant like me? Majid, what do you want to tell this aspirant?
Thank you, Tayo. So my advice is simple, right? Those telling you to prepare ahead, they are very correct, and those asking you to rest, they're also very correct, right? So I would advise you just find a balance between the two, because I think that what worked for me in law school, right? One of the things that worked for myself and a couple of friends was that because Esther mentioned during her presentation and Tayo also mentioned that law school is not law school is not difficult, right? It's just because you are consuming a lot of information within a short period of time. I could remember during civil litigation, documentary evidence. My lecturer taught me documentary evidence for the entire second semester in 400 level. I did documentary evidence in just a single day in law school, right? So you are consuming a lot of information, right? And the only way I was able to assimilate those things fast in class is when I had idea, all right, I had a residual knowledge of those topics, right? And how did I get those residual knowledges? Because I had read ahead of those classes and probably even before we resumed law school, right? So if I'm advising you from a personal standpoint, right, what I did was because we had time before law school, right? So I read, but I was not reading as though I was preparing to write an exam on my first day of resumption. I was reading as though I just want to have an idea of those topics before going into law school, because by doing that, I also had the time to rest as much as it's needed for the job you are going to do in law school, if I'm permitted to say it's a job, or the task you are going to do in law school, but also you want to have some form of residual knowledge going into law school. So I think that you just need to find a balance. But it's advisable you rest well and you also have a working knowledge of your topics. Thank you.
Thank you so much, Majid. Next question for Eko Dayo. This person says, assuming you don't remember the exact section of the legislation, is it sufficient to just mention the name of the legislation? For example, rather than say pursuant to section 30 of Company and Allied Matters Act, you just write pursuant to Company and Allied Matters Act. I think this is nice, but I don't think you get any mark for it. But I think Ekodayo, please respond to this too.
Thank you, Natayo. So like you said, I mean, it's just better for you to just state your principle, general rule, exception, and then apply because you get your marks. But if you now want to cite the statutory authority, you have to cite it well. So you have to state, oh, section 30 of Companies and Allied Matters Act. You don't need to say, because as criminal litigation lecturer will be like, why are you giving me ACJL? What part of ACJL are you referring to? So if you don't know the section, just state your principle. You don't need to put, oh, caution to administration of criminal justice, because they are not really citing any statutory authority in saying that. So if you don't know the appropriate citation, just if you don't know the appropriate section, just give your principles and you get your marks. I don't know if that answers the question.
Thank you. Thank you. And just something crafty that I know I used to do. If I don't know a case, I don't think I did this in law school, I can't recall, but I'll just say it has been decided in a number of cases. Then I don't state the case. I think it's clever, but you might not get an answer for it. So we're hoping you remember. But if you don't remember, it's fine. You get your marks from other questions. Then we have another question here that this one will be answering. This person says, I'm a bar aspirant, but please, how do you handle corporate law and civil litigation, as they are both bulky courses? This one, how should this person answer corporate law and civil litigation?
Yes, so understand that corporate law and civil litigation are very bulky courses. But what I did in my time was that I kind of allocated more time to them. Not like I concentrated on them like so much, because they always say that, oh, you have 5 wives that you should love equally. So I'm not saying that you should like put all your efforts in corporate law and civil litigation, but I think knowing yourself is very key in this, because
Hello, Adeswa. If you are speaking, we can't hear you.
I know those courses while not neglecting the other courses as well. So you can just dedicate more times, and like I think Wako mentioned mnemonics. Mnemonics were very important, were very useful for me in corporate law and civil litigation, especially. Then for civil litigation, I think, and there's a act civil litigation, I think you should just like practice your drafts. If you have all your drafts on lock for civil litigation, trust me, you are 70% good to go in civil litigation. So just practice your draft and draft and draft and draft. And because civil litigation is majorly drafts, so just practice your draft, then know the principles, and I'm sure you'll be fine if you can practice your drafts properly. And for corporate litigation, you can use mnemonics, because I know corporate practice is broad and is not very relatable. So you can just use mnemonics for corporate practice.
Thank you for that answer. And I'll just add that another way to help yourself with these really bulky courses is that try to outsource your learning to other people. Like there are times when I'll be going to buy food or I'll be getting ready for class and my roommate will be asking me questions. And within those times, I've retained some information. So you don't only have to learn and read when you're sitting on a table with a pen. So have discussions, let people ask you questions, ask them. If you get it wrong, do the correction. I feel like that's another way to learn. So we have this next question that Esther would be answering. And the person said, you mentioned in one of your slides that don't use abbreviation ever. How does one cite multiple sections of long-winded legislations in that case? Can one cite in full the first time in a question and then indicate an acronym for the purposes of that legislation for the rest of the particular question, or what's the best approach? Esther?
Hi, Taya, thank you. So I recall that at the time we were in the Nigerian Law School, this was actually one of the points that the lecturers had emphasized over and over again. That was karma. Was I say that you just have to write in full. And whilst I understand that it can be time consuming, and sometimes I don't particularly understand the rationale for writing in full every time, it appears that the suggested approach that the lecturers always prefer is that you actually write in full. Maybe it is because there have been instances where, when they say list the statutory authorities, people don't actually get the full meaning of those laws. I think it might have been one of the reasons behind it, but it's advisable that you actually write in full across every time that you are answering a question. And because of the way that answering of questions in Nigerian Law School is structured, you don't particularly have to keep listing sections across a particular question. It can actually be that you put what the general rule is, and then you say section 23, for instance, of the Companies and Allied Matters Act. You are not particularly expected to say section this provides this, section this provides this. It's just to really state what the principle is, and at the end, you can just write what the relevant section is. So the preferred approach by lecturers at the Nigerian Law School is that you actually write out the name of the legislation in full. So whilst I understand again that it can be time consuming, I would advise that you stick to that. Thank you.
Interesting. Thank you, Esther. Just to add on, I don't know if I should say this or not, but you have to check with your lecturers from your campuses, of course, but one of our lecturers told us then that if you have the full the full name of the statute, Company and Allied Matters Act 2020, the first time, put in brackets, comma, then subsequently under that same question, you can just refer to comma. But I don't know if that has changed. I went to law school a long time ago. You will have to check with your lecturers. Another question for Victor now. This person says, when citing an authority, must it always be after the principal, or can we put it anywhere? Victor, can you put it anywhere? And the person was kind enough to give an example. Should the authority come at the end or in the beginning of your answer?
Right. So it's kind of a mix of both. Depending, I think to me, it's a mix of both, depending on how the question is or the question you're answering. So, for example, if the question I'm answering is based on one principle, that one case law, I'm citing just one case law, one authority, I can first talk about the principle and just add. So, for example, I think Kingsley gave an example of jurisdiction in his question. You discuss, that there are 4 grounds that the court ruled the court must have in place before jurisdiction is established. You discuss the principle, and then you put Madukolo versus Kemdilim, and that's it. That's one principle, one case law. I would do that. But if I have a question where I'm supposed to dissect more than one principle within one question, or within one sub-question, as the case may be, my trick would be to actually take the other approach, where I would first start by saying, in the case of Madukolu versus Nkem Delim, the court ruled this grounds by which jurisdiction is established. You list the 4 grounds. However, say in a different case, I'll now say, however, in the case of Attorney General of Lagos State versus Attorney General of the Federation, the court ruled that the Supreme Court has exclusive original jurisdiction on this, that, this. So in this particular situation of the question, or this question, I can't just put 2 principles side by side and then just throw in 2 case law without specifically saying which case applies to which. It seems like a lazy approach to it. But you see me attaching those cases to those principles in a sentence. I won't even say, I'll say the principle and then say the case law right after, say the principle, say the case law right after in this scenario. I would actually link it to say, okay, it was decided in this case that this happened, and it was also decided in that case that this happened. I hope this kind of sums it all. But if you have a situation where you have just one principle you're discussing and one authority, say case law or section, I believe you can just state the principle as it is, apply it to the case, to the scenario they ask you, and throw in the authority right after, So I hope that kind of settles it.
Yes, it does. Thank you, Victor. And just to restate again, as long as you have the correct principle, you have your authority, the arrangement doesn't really matter. As long as you have the right thing and your examiner sees that you have this answer. Thank you.
Get your mark.
Yes. Another question here for Majid. The question says, as a law school aspirant aiming to have some residual knowledge before law school, what resource can one use? Do you advise textbooks, notes from law school students, slides, or law school handbook? As some of these materials conflict sometimes. Majid.
All right, thank you, Tara. So I would advise you go for what you are what's easily accessible to you, right? If you can lay your hand on textbooks, that's fine. If you can lay your hand on law school handbooks or notes from your seniors who are presently in law school, I think whatever you can lay your hands on, because the goal in itself is to just have an idea, is to have a working knowledge of this topic, is to go into the class or go into law school with a basic understanding, or so that those, basically I say it that in simple terms, so that those concepts don't sound strange to you. That's the major reason why people advise you to read before going to law school, so that those concepts don't sound strange to you. So if that is the goal, I think either of law school textbook, law school handouts, notebooks from anybody, from any of your senior, or handbook will work. So I think that's the response I'll give to that. I don't know if Tayo permits me. I would like to just pass a brief comment on an earlier question that has been answered by Adeswa. which was that,
Okay.
please, how do you handle corporate law and civil litigation, as they are both bulky courses, right? I've had a lot of friends, colleagues, and juniors from uni ask me that same question. And one thing I found is that when I ask them, why do you think this course is bulky? Why do you think this course is, why do you think, because everybody mentions civil litigation and corporate law, and you ask them, why do you think this course is bulky? For instance, civil litigation, this will summarize it excellently, that is a lot of drafts, right? You are basically doing plenty of drafts. And when you see people, when I ask this question, they tell you because in civil litigation, for instance, you are learning over 50 something draft, you are learning over 60 something draft. So it's a lot of information to consume. And I tell people that I think you are just you are falling into a trap set by some, I don't want to use the word, so some few set of persons, right? Because what you find in, I've seen those lists of drafts that's flying around. What you find is them listing motion for interlocutory injunction, motion for ex parte injunction, motion for substituted service, motion for this, motion for that. And personally, I say to people that in civil litigation, you don't have more than 5 or 6 drafts. Because when you see motion for this, motion for that, motion for this, when you list out the various motion you are drafting, at the end of the day, you have 20 different motion. But trust me, you are not learning 20 different motion. You are learning just a single motion. The only thing that changed is the rule of court, the designation of parties, and the prayers, which is not something you are memorizing. It's something that comes with an understanding of the motion you are drafting. So all you need to learn is a single motion, how to draft a motion, and that works for you. So there is really, so that's just to allay the fear that you are drafting 77 motions, you are memorizing 77 drafts. Trust me, you are just memorizing one draft for motion. You are memorizing one draft for letters. People say that you are writing application to court for this, application to court for that. I promise you are just memorizing how to write one letter. So it's just as it changes. And when you go to corporate law, when you ask that same question, I've asked a lot of people that question, they tell you that, oh, you have plenty resolutions, you have plenty minutes of meeting, you have plenty notice of meeting. And I keep telling people that honestly, corporate law is like, I even think property law has more drafts, or criminal litigation has more drafts than corporate law. Because trust me, in corporate law, you're looking at resolution, you're looking at notices, you are looking at letters. So you can box them into just 3 or 4 different drafts. For resolution, nothing is changing beyond the resolution is brought pursuant to what section of CAMA. For letters, nothing is changing beyond designation and content of the letter. For minutes or notices of meeting, it's just the resolution, the heading of the notice that will change. So all of these drafts in your list, you can see 72, 52. But honestly, trust me, when you sit down and write it down, you can see that the draft for corporate law is either it's a notice or a letter or a minute. So I just want to pass that comments before, I guess that will be my last thoughts on this. So thank you very much, and I wish everyone the best.
Thank you so much, Majid, for your answer. Thank you so much. And just add a little on the earlier question, law students that want to have residual knowledge, I would advise that, and I know for you to ask this question, you know how important it is that you pick the right material, because what you have sometimes is that you will learn something before coming to the law school, then when you get in, the lecturers are saying something different. Or take, for instance, during our time, there was a different company's law in place. Then when we came in, we used CAMA 2020. So you need to bear in mind all of these things. And Majid has said, you are just reading these things to have an idea and not to cram the teeny tiny details to write an exam. Because I know someone that read a particular material, which I will not mention. He told me he had finished the syllabus, and when he resumed at the Lagos campus, he told me that he didn't even want to be attending classes, that he had done all of this. Then the snap test came, he got less than 40%. And this was someone that had supposedly finished the syllabus from all the materials he read. So when you want to prepare, I would say you should use trusted materials. I would say the handbook. I'll say because it's coming directly from the law school. You can trust it unless they make certain changes. But yeah, so the next question that Adeswa would answer, the question says, how can one have an effective study group in law school? If you used a study group, what practices and techniques did you use that helped? Adeswa, please, would you like to respond?
Okay, yes. So for this, I didn't really use a study group until later in the law school. And I think it actually worked because what I used study groups for was for past questions. So I think 3 of my friends, we had a group where we practice past questions, and so we can just see how other people answer questions. Before when it was close to the exam, I just used to read on my own and just ask my roommate that, oh, what does she understand by this? It was just majorly me and my roommate. But when it was close to exam, we started doing the past questions with the group, and it was really helpful because there's sometimes that you just I and my roommates we just think that, oh, we know this thing very well, or this is the best way to approach this, and then my other friend will come and answer the question in a different way and in a better way. So we just were able to see it from see answering questions from different perspectives. So I personally I don't read in a group. I don't know how to read in a group. So I just used to read on my own, try to understand it on my own. Then when it's time for practicing past questions, that is when I really test my understanding of what I've read, and it really helped me. All of us in our group had a first class, and it was really helpful. The group was really helpful. So I recommend having a group where you practice past questions together, and not just the theory aspects, also the MCQ. We used to buy, there's this in Lagos campus, there's this MCQ sheets that they used to buy. So we just try and we shade the answers and time ourselves and just practice together. So I think that's the best way to use group study groups. Sorry.
Okay, thank you for your response. Thank you so much, everyone, for your engagement. You guys have been very amazing, asked beautiful questions. So I just have one very last question to ask our panelists before we end the call. And the question is, I think one that everyone has on their minds, because you have one day between each of these exams. So how do you revise during your time? How did you prepare every day? Were you reading your textbook? Were you reading your jottings? How did you prepare within each day you had the exams? So we can start with Esther, that is nodding her head. She has a lot to tell us. We'll start with Esther. Then Majid will come in.
Okay, thank you, Omotayo. So for me, after each course, I would eat, of course. What I did was to have a jotter, and I think I just, touched on that a bit whilst I was speaking. I had a jotter where I had principal, authority, exception, authority. So that was what I did, right, just the day before each exam, because truth is, there's absolutely no world in which you're able to read all the topics again just before each exam, right? Because you barely have about maybe 12, 15 hours, and you want to ensure that you're also still resting well in that period. So what I did was to have a jotter where I had all of those highlights of the principles, cases, and that was what I used each day before the exams to prepare ahead of the following day. Yes, thank you.
Okay, thank you, Esther. Majid, how did you prepare? Or how did you revise during the exam week?
Thank you. Amata, can you hear me?
Yes, I can hear you clearly.
Thank you. So I think for me, right, I don't so let me just say that I think a lot of us, we already know what works for us, right? Esther knows that our jottings were the best for her. I was not the kind of person, I don't jot when I read, right? That sounds strange, but I don't jot when I read. I just read my textbooks and I read my notebooks. So for me, I decided that ahead of the exams, there was I do not have time to read textbooks again. So for my revision, it was just simply my notes, because I ensures that my notes were as comprehensive as possible. I took notes of everything that was taught in class. And when I'm reading my textbooks, any authority that I don't have in my notes, I just included it. So at the end of the day, during revision, I was just reading my notes. So that was it for me. Just know what works for you and what is convenient for you. I think what I can just advise, right, is that is not the time to be reading foreign materials, and that is not the time to be reading bulk, so basically saying the same thing that Esther has said. you are reading what is the most comprehensive at that point in time, because you have limited number of hours to revise. So thank you.
Okay, thank you, Majid. Then Victor, do you want to come in?
Yeah, thank you very much for that question, Taya. So the week of exam was pretty intense for me. And mind you, this was against the backdrop of the fact that I was already very much prepared for the exams. I believe anything you need to learn on that week shouldn't be something completely new, right? Because you've had enough time for that. But if the case demands that you do learn something new, then go for it. But for me, that week, I did two things. One was to read my note. I'm a very elaborate note maker. It's not textbook material, but it's something that you can read. I guess with like 10 hours or so, if you take 10 hours straight, which is almost what I used to do after the exam, it was a bit intense. I would read my note again from front to the back, right? But then also I would focus a lot more on what I would call topics I hate, right? Topics that I knew that if they came out in the exam, if I didn't do extra revision on it, it would really mess me up. So for corporate law, sometimes I had issues with restructuring at the time, and I would in the week of exam, I would read restructuring a lot more, and I wouldn't give as much attention to topics that I knew I was solid at, right? So even for those topics like restructuring, I would actually almost start from the beginning again and take out like an hour or two to read them to make sure that I was a bit more grounded than I was, But I spent a lot of times going through my notes a lot over and over again. So this took a lot of hours. I never really sacrificed sleep per se, but I was having a lot less sleep during exam week. That's for sure. It was a minor sacrifice that I believe paid off. And yeah, that's basically what I did. Read my notes over and over again and focus a lot more on topics I didn't like, topics that were not that good to me. Yeah.
Okay, thank you so much for your response. So we have two more questions. People still have questions. So this question that Ekundayo would answer, the person says, in answering MCQ, can you read the question first before the scenario, or scenario before the question? Ekundayo, please, can you answer this?
Yeah, so that can be very tricky, right? Because I know I did both. So I feel like it depends. It depends on how long not really how long the scenario is. Maybe if you read the question and you think that okay, you need to go back to the scenario, then you need to read the scenario. Because most of the time the scenarios will help. So I feel like it's advisable to read the scenario first. To just quickly do a brief reading of the scenario, then proceed to answer the question. Because most of the time the questions might not really relate to the scenario, but most of the time, a little bit of attention to maybe an information in the scenario would help you answer the question better. So you need to do both. You need to do both. You need to read the scenario and then proceed to answer the question. So it's advisable to look at the scenario first before proceeding to answer the question. So that's better.
Okay, thank you for your question. Then we have another question that Ade Shewa would help us answer, and it was an additional question from someone that asked earlier. The question says, please, what's the most efficient way to remember procedures in corporate law, since there's so many of them? And I'll just say this before Adishera comes on to answer. There are so many procedures, but what you would find is that for some of the procedures, some steps cut across, like paying stamp duties, stamping your memos, or calling for a meeting or resolution, things like that. So I think a good first place to start is to look at all of these very long procedures. I think for post-incorporation matters especially, you have a lot of steps that cut across many of the procedures. So you can just help yourself by identifying those common steps. You have at least 3 of them. When you're listing statutory authorities, that you start from the general ones, RPC, Constitution. So you can do the same thing for some corporate procedures. Then you now add on specific steps for the question that they're asking you. But Adeshewa, please, if you want to provide more answer to what I've said.
Yes, so just like you said, their general procedures. I know that Mrs. James used to say that just first write those general ones, then you can now start adding based on the question. And also you can try to just to just rationalize what you're the procedures you're like. Now if you want to do something, if there's a particular procedure you want to learn, you can just think about it that, okay, if I want to do this, what are the things that I would likely need apart from just knowing it, and just try and rationalize it and just try and write it down. Then also I cannot overemphasize mnemonics. I would always say mnemonics. I'm a mnemonics babe. So just try and use the different mnemonics for the different procedures, and you'll see that it should assist a great deal. So yeah.
Thank you, Mnemonics babe. Thank you, Peter. Thank you, Esther. Thank you, Majid. Thank you, Ekodayo. Thank you, Wapo. Thank you, Peter. Thank you, everyone on this call. Thank you so much for your time. We trust that you've had value for your time. Please pay attention to all that has been said. Be sure to filter through and see again what works for you. What works for you. We are rooting for you, always praying for you. And we hope that next year or in 2 years' time, you guys will be on this side giving out tips and telling aspirants what to do. Thank you so much for your time. We wish you the very, very best. Thank you. I think we can end the call now. Thank you and all the best. Eat, sleep well. Don't try to read everything in one day. Sleep well. Thank you and enjoy the rest of your Saturday. Thank you.